So, hello everyone. Welcome back to those that have been following along with this quarter, and welcome to anyone joining us for the first time in this series today. As Mary mentioned, my name is Tariq Hafiz. I am a Technology Center Director in TC 3600, and in 3600 we handle a diverse range of patent applications, including software, business methods, navigation. We have some mechanical in devices, so lots of fun stuff. And I oversee business methods. I've been a director of business methods for many years. I was a supervisory patent examiner in business methods for a very long time as well. So today we're going to discuss common mistakes during prosecution and support options after applicants have filed. But before we continue, I want to give a brief disclaimer. Oops, sorry. Let me go back to the previous slide. The disclaimer was quick. So note that content presented today is for informational purposes and should not be considered as legal advice. You should consult with an appropriate sources for legal authority and guidance on these matters. That being said, let's get started. So the objective of this session is going to be patent basics, filing requirements, common mistakes, post-filing procedures, support, and resources. We'll then move on to our focal point of today's talk, which will be the common mistakes and how to fix them, as well as post-filing procedures. Okay, so you've been following along in the previous 7 classes of a path to a patent. You should know the basics of not just intellectual property, but patents, and mini review should be quite familiar to you. If this is your first class with us, this might be new to you, and I recommend signing up for a path to a patent series next quarter. So types of intellectual property, right? You have patents, trademarks, copyrights, and trade secrets, right? And so these are the 4 major types. As you can see, trade secrets are just what they sound like, secrets, right? Things like Coca-Cola, KFC. The effectiveness of a trade secret is determined by how well you or your organization can keep the idea under wraps. Trade secrets do not have to be registered, they do not get published, and they have to stay secret. So I think Coca-Cola and KFC have done a pretty good job over the years to keeping their recipes secret. Copyrights, they protect creative works. Think of things like music, movies, software. It's basically software listing, right? Program code, books, and term for copyright is the life of the author plus 70 years after author's death. For works made for hire and anonymous works, copyright protection would be 95 years from publication or 120 years from creation, whichever is shorter. Trademarks protects brands as well as consumers because they identify the source of the goods or services. Trademarks allow customers to know who they're doing business with. Term for protection lasts as long as the mark is in continuous use in connection with goods or service. For example, Coca-Cola first laid claim to its trademark in 1987, and this trademark has been in continuous use since then. Because the company continues to do interstate commerce using this trademark, the trademark will continue to be theirs until they discontinue business in the US. And finally, the fun part, right? Patents. Patent law is governed by Section 35 of the United States Code. From this code, we know that a patent may be granted to any invention that is useful, new, and non-obvious. And patents actually have protection of 20 years from filing. So since we're the US Patent and Trademark Office and this series is Path to a Patent, let's focus on patents, right? Patents, it's a property right granted by the government of the United States of America to an inventor to exclude others from making, using, offering for sale, or selling the invention throughout the United States, or importing the invention into the United States for a limited time in exchange for public disclosure of the invention when the patent is granted. Again, that limited time is going to be 20 years from filing. So there are sorry. Why does this keep advancing? Sorry about that. Okay. Okay. So there are 3 key parts to the statement, right? So the first, this is the right to exclude others from doing your thing. It is not the right for you to produce a thing or use a process. Here, we like to note that USPTO cannot help the inventor find manufacturers, just the same as USPTO cannot help an inventor sue someone else for infringement. What the USPTO can do is define the scope of your invention, which creates the intellectual property that we call a patent. In turn, your issued patent gives you the right to stop others from making, using, offering for sale, or selling or importing your invention in the United States. Again, as we mentioned, this is a US patent, so your protection stays in the United States. So this for a limited term of exclusive ownership. So the US intellectual property system is built on a trade-off of disclosing how to make and use the invention with a limited term for what we call a regular of utility patents. Like I mentioned earlier, the term is 20 years from the earliest filing date. We do this to both encourage innovation and reward inventors. If the subject of a particular intellectual property is continuously owned, it would require everyone to license or pay fees to the owner forever, which would discourage further research and improvement. So the system is built so that when a limited right has expired, the general public may make use of the invention without those fees or legal issues that would be required during the limited term. And I think we've used this term sort of a quid pro quo system. You're getting this limited monopoly for 20 years. In exchange, you have to disclose, how to make and or use that invention. And after 20 years, it becomes public knowledge. And it also encourages innovation, right? When something's out there, it encourages other people to innovate and come up with better ways of doing things. And so that's why we are sort of leaders in innovation and intellectual property, is because of our strong patent system. So the third portion of this is the issued U.S. patent provides a territorial right, meaning it is only applicable to people within the U.S. and to imports coming into the U.S. So if someone in a foreign country knocks off your device and sells that knockoff in a different foreign country, the rights of the U.S. property holder is not infringed unless they also hold a patent in that country. So that's why you see, patent applicants in this country from all over the world, as well as in other countries. Like our U.S. companies will file patents in different countries throughout the world to protect their inventions in those countries as well. So there's no such thing as a worldwide patent. There are a couple of programs that are used to streamline filing to multiple countries, and one in Europe where a European Patent Office protects inventors within the whole of the U.S., but a U.S. patent itself is not enforceable in a different country. So if you want protection in any other country in the world, you'll have to file a patent application in those countries and get a patent. So there are three types of patents. You get utility, design, and plant, right? And so in terms, utility patent, which is often referred to as a regular patent, protects the way the thing is used and works, while a design patent protects the way a thing looks. And both design and utility patents may be obtained on an article if invention resides both in its utility and ornamental appearances. While the utility and design patents afford legal separate protection, the utility and ornamental of an article are not easily separable. Articles of manufacture may possess both functional and ornamental characteristics. Please note the term protection is different between utility and design patents. Utility can be covered for 20 years, while a design patent is only good for 15. So one primary importance in a design patent application is the drawing disclosure, which illustrates the design being claimed. Unlike a utility patent application, where the claim describes the invention in a lengthy written explanation, the claim in a design patent application protects the overall visual appearance of the design described in the drawings. It is essential that the applicant present a set of drawings of the highest quality, which conforms to the rules and standards of MPP 1503.02. This is a manual of patent examining procedures. So there's a specific section on rules governing design, drawings for design patents. So there are also plant patents, which are infrequent. These are used for asexually reproduced, distinct, and new variety of plant. So they're not for plants found in nature. So for more information regarding plant patents, please see MPP chapter 1600, and plant patents have protection for 20 years as well. Okay, so provisional versus non-provisional. So let's take a quick overview of difference between the two. Provisional applications, remember, provisional means maybe, I guess, it's or preliminary, right? So provisional applications are allowed for utility and plant applications, but not for designs. So there's no claim requirements in provisional applications. They're not published and they're not examined. This all means that a provisional application itself cannot become a patent. So remember, provisional applications are not required, but just some inventors use those 12 months to decide if they want to spend a little bit more money to file a non-provisional application. The whole concept behind provisional application is it gives you time to develop your non-provisional application and gives you that earlier filing date. You want to really protect your invention as soon as possible, but you're not ready to really file a non-provisional right away. You need some time. So inventors will file a non-provisional. It gives them about 12 months to really perfect their non-provisional application, whether they need to, I don't know, craft claims, drawings, clarify some of the other language in their application. So they get really additional time to do this. It's a really low-cost way for them to get started on their intellectual property protection. So the non-provisional applications are applications that actually can become patents because they require claims of your invention. And in order to benefit from the priority date established by the provisional, there must be full support in the earlier provisional application of whatever is being claimed and then later non-provisional application. There's a lot of caveats to this. Sometimes you may not have enough disclosure in your provisional, but you need to add more. And then so it gets a little complex, but there are provisions where some portions can still get that earlier filing while others may not. But again, it's very important to use provisional to establish earlier priority date. If you're thinking about it, again, consult your legal advisor on that as well. So again, I think I may have mentioned some of these benefits of provisional applications earlier. We're going to go over this again. If a provisional patent application cannot become a patent, why would anyone bother to do it? Well, again, as I mentioned earlier, they're useful in a sense that allow you to establish priority date. That's up to 12 months earlier than a non-provisional. And it's, again, very inexpensive to do that. And if applicant chooses to do so, remember, provisional applications are not necessary. If you're ready to go full force on non-provisional, you're perfectly okay to do that. So, but by this time, right, it helps applicants determine if they want to spend more money on a non-provisional. And then what kind of factors might be involved in this decision? Well, applicants could have time to do some market research. They might include pitching the product to potential investors. And inventors can do pitching without worry because the term patent pending is now attached to the invention disclosure. While applicant has filed a provisional application, it is considered pending. So if the applicant forgets to apply for a non-provisional, or if the non-provisional is filed but goes abandoned, then the patent pending no longer applies. If the application does become a patent, then you will use the term patented, of course, right? Again, if you decide while this provisional application is pending, and you also gives you time to do some research, you may search to see if there's other inventions like that out there, and that may also lead to your decision on not filing a non-provisional. So some of the other things applicants can do during this provisional applications is to get a patent attorney or a patent agent. You can look up available patent agents and attorneys on our website under Find a Patent Practitioner search. And again, this attorney is not needed for filing or for prosecution of a patent application, but it is highly recommended. We do have some inventors, we call them pro ses. They do not use an agent or an attorney, and they don't try to prosecute applications themselves. It can be challenging if you don't have experience, and there's just a lot of rules and procedures you have to follow. And within the office, our examiners do try to help our pro se applicants as well. But again, it's definitely easier if you have someone representing you. Okay, so now you filed an application, you want to know what happens next, right? So if you choose to file a provisional application, then you have two paths, right? You can file a non-provisional, or after 12 months pass, don't file it, right? So the one path at the bottom on not filing, after 12 months from the day the provisional application is filed, you don't file a non-provisional patent application, okay? So your non-provisional application will go abandoned. It's no more patent term for your invention, so your marketing on patent pending should stop. Since provisional applications are not published and are not examined, no one will even know that you filed. So the other path on top, you have possible two outcomes, right? The application eventually goes abandoned or gets granted. So when you file that non-provisional application within 1 year uh, of the provisional, this non-provisional application will run its course of examination by an examiner. We call it prosecution. The examiner will look at your case. Uh, they'll start discussion between you and an inventor or attorney to determine, we call it meets and bounds of your intellectual property rights, because that's determined by the claims, right? Either that becomes a patent or, it goes abandoned. It depends on how the prosecution goes. What the examiner does is they'll look at your application, look at the claims, they'll do some research, find some other similarly invented patents and or non-patent literature to determine whether or not your non-provisional application deserves a patent. If they do, you may get a patent right away. Examiners may say, "Oh my God, I can't find this. This is incredible," and send you a notice of allowability right away. Or the examiner may say, "You know what? This is very obvious from patent X, Y, and Z," and they'll write a rejection, and the process goes back and forth until you get to the point where there's an agreement between the examiner and you and or your attorney on allowing claims or allowing this application, or you make a decision saying, "You know what? Based on examiner's work, we're not going to proceed this further. The case goes abandoned." And there are other options too. You can always appeal examiner's decision. We call it patents trial and appeal board. So there are other options on this appeal. Again, there are extra fees associated with this appeal, and it's not guaranteed, the patent trial and appeal board will overturn the examiner, but it just depends on, your legal guidance or how you feel on your position in relative to what examiner's position is. So anatomy of patent publication. So once the patent application is published, these are some of the things that we look at, right? 18 months after filing, this non-provisional application is published, and it's something that we call U.S. pre-grant publication, or PGPub for short, right? It's possible to be not published until the patent is granted, but that's an extra cost option if you choose to, if you decide you don't want this published. So again, congratulations, you've been just published by the U.S. government, right? So this slide shows an example of what a PGPub generated 18 months after you file a non-provisional patent application. This is what it looks like when the USPTO published it. It almost looks like a patent with a few things that are different, right? So again, if you see part 4 of the forms and formatting requirements for your filing, I want to show you what all the PGPubs look like, because examiners look through these to find prior art, right? As you can see, the title, the published title, the inventor's name, patent owner's name, we call them assignees, the published patent filing date, and then the publication date. Publication happens 18 months after filing, unless applicant is paid to have it not published. The cover will also include drawings, if the applicant submitted one. This helps the public understand the invention, so it belongs on the front just like the title and the abstract. Page after the drawings will start the detailed written description, which is similar to a journal article, right? Abstract will be on the cover, and the rest of the publication will include background of the invention, summary of the invention, and the detailed descriptions of the drawings. So the patent will look exactly like this, except publication number will be replaced with a patent number line. It's easy to tell if a document looks like this in a publication or patent by looking at the top right-hand number, right? You see a pub number. If it starts with a year and a slash, that's a publication. If its number is, generally speaking, over 1 million, that's a patent, right? So USPTO has granted 10 millionth patent in 2018, and I'm not even sure what number we're on today. We publish patents every Tuesday. So again, do we know if this application became a patent? There's no way to tell from this document, right? There are many people who think that an idea submitted to the USPTO, which was refused a patent, is therefore ineligible to be prior art because it was refused. Well, the document right here is the reason why those applications applications are eligible. This is a publication available to the public as the date of publication, which is on the top right. The publication is available to the public regardless if this becomes a patent. So therefore, this publication is able to be used as prior art, just like anything else, like an article, a non-published literature, anything else. If it's published, examiner can use this as prior art. So within that, you have brief summary of the invention, right? This includes broad overview of the invention and its environment, followed by a brief description of the drawings. There will list each numbered view of the device, cross-sections, flowcharts, molecular diagrams, anything that's really on the drawings. After list what they view shows in a very brief and then a detailed description. Applicant would include all part numbers from the drawing in detail. Notice the last section, and this would be the claim section. The claim defines the legal boundaries of the invention. This is a section of the patent application that is sought to be legally enforceable. Remember the non-obvious and novel standard to obtain a patent. Examiner will determine the novel and non-obviousness of your claims only in light of your description. The entirety of the description is not assumed to be present in your claims. So here, remember, the claims are really one of the most important parts of the patent application. That's where your legal advice is recommended, because you don't want to make the claims too broad. It'll be easily rejectable. Too narrow, you may get a patent, but you may not be able to enforce it. So there are a lot of nuances on strategically drafting claims. Very important part of your patent application. So this is what a patent looks like, right? You want to see right away, you'll see it's a patent, date of a patent, it's got a patent number, right? So you always look at the top right corner if it's a patent number or PGPUB. So when was this filed? Well, if you click next, it was filed on April 9th, 2001, right here. And this is important, right? This is what is used in the US as first to file system. So if somebody uses your invention, and if you filed it back in 2001, that's your priority date. So it's really important. Filing it earlier, it gives you this advantage. Another thing, one of the things, I don't know if they talked about it here, another thing that's important is on every patent, you'll see a name of the patent examiner. You have a primary examiner and an assistant examiner. When you have two of these, assistant examiner has actually examined the application, and primary examiner is actually the one who approved it. So we call a signatory authority, like we have primary examiner who go through a rigorous procedure to earn the right to be able to sign a patent application to issue into a patent. Assistant examiner is still trying to earn that right. So you have two signatures, that means two people have looked at this before issued to a patent. When you only have one name, that's a primary patent examiner, that means the primary examiner examined it and issued it on its own. Didn't have a junior examiner actually work on it, so there was no oversight from that examiner. So this is also interesting because a lot of examiners are very proud of all the patent applications that they've issued into patents. So it's a nice little tidbit that I wanted to throw that in. So if you want to look what this patent is all about, well, you look at the title, the abstracts, it shows you the whole front page, the drawings. So this is about an adapter changing an inline roller skate into an ice skate. This adapter clamps into the spindle rods of the rollers in order to insert the blade below the spindle rods. Let's see. You can tell there's classifications right here. A lot of, I don't know if you know that, but we try to classify patents into different areas. So it's easy for us to know what's grouped together. It's easier for examiners to do research, easier to identify where to search similarly liked patents. The classification is also very important. And it also helps examiners determine their field of search. And another thing you can tell from this is you can tell if there was an attorney. So you have an attorney and agent right here. Sometimes we don't have that, then you know the applicant filed it on their own and they were pro se. All right, let's see. see, this is the filing date. So going through this. Okay. So filing requirements of a non-provisional patent application, right? So again, publication only happens for non-provisional. They're published at 18 months after filing or when patented. Provisional or maybe applications are not published at all. So filing requirements. A complete non-provisional utility patent application should contain the elements listed below, arranged in the order shown. Right? Utility application, transmittal form or transmittal letter, application data sheet, specification with at least one claim. Remember, claims should be start on its own page. Drawings, if necessary to understanding of the invention. If drawings are necessary, they should be clearly mentioned in the above specification. Executed oath or declaration. Please make sure to do this properly at the time of filing. There are more fees to file after the original filing. Nucleotide and amino acid sequence listings when necessary. Large tables of computer listings when necessary. Appropriate fees. So once you file all this, you should be getting a filing receipt. So what does your filing receipt look like? So this is it right here. If you filed an application with the data sheet or ADS, all this information is really easily pulled from that document and regurgitated for you to make sure it is correct. So this receipt is to make sure that your name is correct, you've spelled it correctly, the IN, the applicant line, that would be any S&E that you have, or if no S&E, that would be an inventor. Here you can ensure that you have the correct, if any, attorney assigned, the one that does all the legal representation for you. So when you have an attorney, remember, you can't really call the office or talk to the examiner. You want to have your attorney do all that. Then it goes in directly into a priority. Priority is a recitation of any previous filings from the applicant that are related to this invention. For instance, if you previously filed a case about shoes, and this instant application is about kitchen appliances, there's no need to cite the shoe case, as it has no relation to kitchen appliance case for which you're seeking a patent. You can also tell when your projected publication date is based on your filing date. Remember, non-provisional applications are published 18 months from filing. Then at the bottom, the receipt will also confirm your filing status, a standard small or micro status, whether it's micro entity, small entity, or regular. Again, the status only affects the fees paid to the USPTO. It does not affect any fees paid to the attorney, but this applicant doesn't have an attorney and is going pro se or by himself. So fees. All non-provisional applications require basic filing, search, and examination fees. These three fees can be mitigated by small or micro entity status if the inventor qualifies. What if the applicant qualifies but the assignee does not? Well, the assignee would be responsible for the standard fees. But our fee schedule is quite large, and there are plenty of extra fees that might be required, like non-filing electronically. We recommend filing electronically. It makes it easy for you and us. And make sure all the information is easily read, right? But if you file by hand by going to the headquarters in Alexandria, we have a customer service window you can go to, or you can mail it to the headquarters in Alexandria. We do charge for the manual handling. Having too many claims is another fee. Remember, standard fee includes 3 independent claims and 20 total claims. If you file more than that, the original filing fee or at any other time during prosecution, this fee can be added. So application size varies as well. So application size fees refer to how many pages it requires for applicant to disclose the invention. So as of October 24, 2024, the fees are applied for each additional 50 sheets that exceed 100. So if your disclosure is 101 to 150 pages long, there will be 1 extra application size fee. If your disclosure is 151 to 200 pages long, second application size fee will be applied, so on and so forth. So the longer your specification, the more fees you'll have to pay. Same goes for sequence listings, and then other fees as applicable. I do encourage you to check the fee schedule on uspto.gov to check all the fees and how much small and micro entity fees change from the standard. There are a lot of fees for different phases of examination. You'll have fees for extension of times, when your case gets allowed or you file appeals. There are many different fees or petition fees. They're all listed on our website under fee schedule. So micro entity status. So this status is at the lowest tier of fees. I mean, there are several requirements to meet for this, right? First, there's a particular form for you to use. It's called SB 15A to certify the applicant meets the requirements. Second, there's a limit on how many previous applications the applicant/assignee or the inventors have been on. If you have filed 5 previous non-provisional applications, you no longer qualify as a micro, and you may qualify small entity status. There's also an income requirement tied to the median household income. This will change every year based on census data. So please check uspto.gov, which will update every year. Finally, you have to certify that this invention is not subject to assignments to, say, an employer or a university. Remember, if your invention was conceived using your employer's or university's money, time, or equipment, you may be required to assign your invention to them. So there are finer details about filing the SBA 15A form. First, make sure that you sign the form and every inventor signs their own form. This is for any assignee and for any co-inventor. As for filing, in the top of the form, in the first name inventor, this will always be the same person, most likely someone whose last name is first in the alphabet. If you're filing this with the original filing, you won't have an application number yet, which means please be extra careful that the first name inventor and the title of the invention is clear and matches the application, so that we do not accidentally assign microentity status to some other case with the title of skate device invented by Smith. This is another reason why we suggest more descriptive titles. Since the USPTO is a fee-funded agency, we do include a number of different types of surcharges. These can be avoided, but sometimes just what happens. Late submissions or untimely submissions of things like IDS or information disclosure statements can incur surcharges. Same with not providing the appropriate parts at original filing. If you filed a non-provisional application with any claims, we have to ask applicants to submit those. Since claims are a requirement of a non-provisional, there's a fee for not following the requirement. So the Office of Patent Application Processing performs initial processing for all new and PCT applications to ensure that applications are in condition for examination. So pre-grant publications are ready for transmission to the International Bureau. There are folks who check to see if you cross your T's and dotted your I's. So they want to make sure you submitted all your fees, your figures are reproducible. So this is all done before an examiner gets to look at your application. So OPAP checks for compliance with procedural requirements like format of the specification, drawings, presence and number of claims, determination of fees and payments, bibliographic information. If any of these are deficient, they will send out notices to applicants regarding any deficiencies found. It won't be from an examiner, so there won't be prior art search done. So at this point, it's not even assigned to an examiner, so you're getting something from OPAP to ensure the application is complete. So this is a sample notice that you'll get from OPAP, right, for missing parts. For example, notice of filing missing parts shows the mail date, setting of the time period for response, items required to avoid abandonment, indication of the fees due, including any filing fees, surcharges, etc., due to as a result of such things as lack of payment or incorrect filing out of the certification of microentity form. Following the instructions on form should put you in a condition to be assigned to an examiner. So your application will not be assigned to an examiner until you comply with everything from this missing parts notice. All right, let's go over some common filing mistakes. So you can just avoid them, I guess, right? The most common mistakes occur in formatting of the specification and drawings. as well as parts of the ADS and the microentity certification forms, as well as some improper signatures. So let's first look at the specification formats. So here are a couple of slides that formatting requirements that we went over in part 4 of Path to a Patent. A single column specification with 1.5 or a double spacing margins and a non-script font are required. Handwritten text scanned into PDF is not acceptable. It is also required that the claims start on a separate page and are numbered consecutively in ascending order. Drawings have to be reproducible in black and white. Everything has to be ready to go at the 18-month mark and be suitable for examiner to examine the case. So the USPT functions in English, and unfortunately, we do not accept applications in other languages. Please see 37 CFR 1.52 for other requirements. Failure to meet formatting requirements when filing may result in a notice of missing parts being mailed by the office. So the title is required, and the title does have to be more descriptive than roller skate. There are lots of roller skates, but the roller skate with adapter for attaching metal blade is considerably more helpful. You want the title to be descriptive of the invention. It's really helpful for everyone, the public as well as the examiner. Claims are required. They have to start on a separate sheet and be numbered consecutively in ascending order. Abstract is required, less than 150 words, and is a concise statement of the technical disclosure of the new subject matter of the patent application. And yes, we actually do count the words. You'll have an examiner count the words, and if it's more, you'll get some type of objection from the examiner. Also, most common section include the background of the invention, brief summary of the invention, and brief description of drawings and detailed description. Now, figures are not required for a non-provisional application, but there are very limited situations that figure will not be necessary for understanding the invention. For example, if your invention is a tangible device, how could you describe a visible tangible device without a drawing? Similarly, if your invention is a method of making something tangible, all those differing assembly steps would be appropriate to have figures. If your device is a chemical composition, the chemical diagrams would also assist in understanding the invention. So while figures are not required in all situations, most applications do have figures. All right, how to file a substitute specification. So maybe you made a couple of typos, maybe you cited some previous art incorrectly or didn't include a brief summary of the invention. Maybe you need to add part numbers to your specification that are present in drawings but aren't in the specification. Maybe you filed something in English that was a machine translation from an application in your native tongue, and you want to replace it with translation by a native English speaker. So there are a couple of ways to do that. For minor changes, one way to amend your specification is to file a form that says specification amendments and include only the paragraphs that are marked up with strike-throughs and or underlines. If you make larger continuous changes throughout the specification, another way to amend is filing an entire substitution. An entire substitution requires three things. First, entire copy of the written description with markups or strike-throughs and underlining. Second, entire copy of the written description, including amendments, without the markups, which is called a clean copy. And third, statement that substitution does not include new matter. So let's talk about parts getting amended and then when it's okay to amend them. Abstracts, written description, and claims are considered parts of your specification. You can replace all of these prior to examination without confusing the record. The examiner will examine the most recent claims, but if you have already gotten an office action, now we have to be clear about the substitutions, which means if you are not amending the abstract, do not include another copy of the abstract in your amendment. Your originally filed abstract will remain intact. Similarly, claims get amended on their own. If you file a response having two sets of claims, this one will get kicked back to you by the examiner. Filing two sets of claims muddies the clarity of the record as to which claims are to be examined. So when we talk about substitute specification in response to examiner's office action, we are referring only to the written description. If applicant is amending claims, the only copy of marked up claims should be submitted as a response and should start on a new sheet of paper. Another important issue here is the statement that a substitute specification includes no new matter. So when a new matter is stuff that had not been previously addressed in the original filing. If you submitted an application with inline skates but never mentioned a phone boot liner in original filing, you cannot include anything about a phone boot liner at any point after original filing. It was not originally filed, known at the time of filing, and applicant wants protection on that. He could file a continuation in part, but that topic of phone boot liner would get a new date. So please see MPP 60804 for more information on what qualifies as new matter. So when an examiner gets these types of application with new matter, you will get the new matter rejection as well. And applicant will point that out. So there are a lot of nuances with that, and anything that new you want examined, you would have to do a separate filing, and it will have a newer filing date. You won't get protection of that earlier filing. So how do you clearly show what was amended? Words are in both written description and in the claims. Strike-throughs, underlines, and double brackets are used, right? A lot of people seem to file these strike-throughs and underlines using track changes features in your word processor. These show up in ink that is not black. In order for our optical character recognition software to work, it needs to be black ink. So please file your underlines and strike-throughs in black and white rather than color in your track changes feature. Again, a clean copy is required for written description amendments. Please do not file one for claims. Submitting two sets of claims at once will confuse the record. As for written description, it is not uncommon that most recent submission is not entered. These do not have to be checked for new matter, and to make sure that the questions are consistent with the rest of the disclosure, they may not be entered by the examiner. And if you add a paragraph, applicants do not have to submit a new amendment changing the number of the paragraphs. The USPTO publication assigns the paragraph numbers that may or may not be consistent with applicants' assigned paragraph numbers. And paragraph numbers are not used in patented publications. Patents use columns and line numbers. All right, let's move on to the drawings. Remember, drawings are required when necessary to understand subject matter. Most applications include at least one figure, and if you're filing a design application, drawings are the crux of the invention. And there are certain drawing requirements specifically for design patents. Please see MPP 1503.02 for details on drawings for design patents. So what are the design and drawing requirements? It needs to be in black and white. Why? Because USPTO publishes in black and white. It needs to be reproducible so that lines are thick and just thick enough to be reprinted. OPAP will send you a notice if your drawings are clearly unreadable or not be reproducible, which is done before the examiner even considers your case. Also, each and every separate view needs to be labeled, and you need to use reference numerals. These replace the names of the part just to keep the drawing clear and not having too much writing on it. Remember, in your specification, you should be naming your parts, assigning reference numerals, and further describing that part. All that information needs to stay in written description and not in the drawings. Reference numerals take care of all that. So the most common mistakes include improper line quality. For instance, if you have a nice black line drawing and then add another line in pencil, the line quality of that pencil mark may not be dark or thick enough to be reproduced. We also see a lot of missing lead lines, which go from the part of the reference numeral. Some of the folks forget to use reference numerals and write in the names of each part, which can be messy. And a lot of issues come up when submitting a photograph. Remember, we can't reproduce your drawing or photograph in color. It's best to submit in black and white. Photographs also tend to include distorting backgrounds, which drawings should not have. The only information in the drawing should be to be able to understand the invention. If anything in your drawings distracts from understanding the invention, this is an improper drawing. Let's also talk about figure labeling. If you submit 6 views on one page, it's improper to label the whole page figure 1. Which part of figure 1 are you referring to? So there are 6 options. In this case, you can label each view as figures 1A, 1B, 1B, 1C, etc. So that you made some errors when filing your drawings, you can label 6 figures on figure 1, or you made 2 different parts with reference numbers 42. So you can make amendments and title the page replacement or new sheet and file it. So application data sheet. So application data sheet is a form that provides bibliographic data for application to us, the USPTO. Bibliographic data sheet includes all the inventors and their addresses, any assignees, any attorney, any priority information like provisional applications or foreign filings. We can see from this slide that this is an optional if you're not claiming priority. But I like to emphasize that it's most preferred form for providing you bibliographic information because it reduces errors in your application process. So it is required for identifying applicants like assignees who are not inventors and for people who are making priority claims to provisional or foreign filing. So there are some also specific examples of inventorship if there are multiple inventors when oaths are incomplete or joint inventors. So some of the issues or common mistakes found in the application data sheets. First, every ADS must be signed. By whom? Well, the registered patent practitioner or all applicants. If there's a company involved, then they do not have representation. Second, ADS must be included if you file a provisional patent application and you want to use that for earlier filing date. If between provisional filing and non-provisional filing, there were a lot of new features, it may not be worth your while to try to get earlier priority because there's no such more information in your non-provisional filing. But if everything is pretty much the same, then you need to have an ADS in order to correlate the instant application with the previous. So 2 more common errors about filed by reference and typographical errors like misspelling names. First, what is filed by reference? Well, there's a section on page 2 of the ADS that asks if you want to file by reference. This is not for people to claim priority. There's a different location for that. It is also not used for any application that includes its own specification and drawings. Filing by reference is for specific purposes of being filed under 35 U.S.C. 111C and 37 CFR 1.5A, which means most applications should not be including anything in the filing by reference section. And finally, typographical errors like misspelling your own name takes time and money to correct inventorship. So let's see. Okay, so how do you fix ADS? Well, much the same way your specification claims the strike-throughs and underlines. So when you do file an amended ADS, call it corrected ADS in the title, and you can file this in the Patent Application Center as well. So how can you see that ADS is being amended but adding language being underlined? Well, here, the corrected ADS has the benefit of the provisional filing date. So you see the underline right here. So, all right, documents that must be properly signed. So let's talk about attorneys and signatures. First, if you have an attorney and is indicated in your representative in the IDS, we assume you have given that representative power of attorney, even if you do not sign a separate power of attorney form. If you have an attorney, that attorney can sign for all documents. If there are multiple inventors and no attorney, it gets a little bit more complicated. In that case, each inventor needs to sign the ADS. You can consolidate that if you assign one person to be the applicant. So what qualifies as a signature? An ink signature on a piece of paper that is scanned in, or for electronic signatures, you could use your name typed between 2 forward slashes or a graphic representation like an auto-generated signature. Again, if there are multiple inventors without an attorney, all inventors need to sign. So here are a few options for slash signatures. Definitely the most preferred method is to have the slash signatures above the type name. Also, now we've filed everything correctly. Let's take a closer look at what happens after filing. So this is the back and forth that I had mentioned earlier. So your non-provisional application, uh, now everything is done. Your basic filing, search, and examination fees cover 2 bites at the patenting apple. The first bite is an attempt, is your original non-filing application. So what happens then? Mostly a lot of waiting. Unfortunately, it depends on where your application is filed, but as of this past year, we're about 18 or so months from getting to a first action. 18 to 20 months, it varies. You'll get your first action, and you enter the gear section of this graphic, right? Many times, not always, many times, examiner is going to do a rejection and or objection. Uh, and the examiner will discuss drawing, claim, objections, anything that he sees that he thinks that needs to be improved. There may be a rejection. We call it under 112 rejections on indefiniteness. There could be a rejection under prior art. We call them 102 and or obviousness rejections under 103. There also could be potential patentability issues regarding your invention, whether or not it's to be even eligible for a patent. We call those 35 USC 101 rejections. So depending on your nature of your technology and how your application is drafted and how the claims are drafted, there will maybe a bunch of prior art cited and potentially an indication of allowable subject matter. A lot of things can happen in that first office session. Some of the applications are filed very thoroughly, very detailed specification, and really very innovative, novel idea or invention could likely get at the first session allowance. You may even not get a rejection. You may go straight to allowance boulevard, right? And sometimes you'll get that rejection or objection, but don't feel bad about that, because there's a lot of ways to correct it. A lot of times your attorney or you will look at those objections, you'll try to correct those objections, and the rejection, it's an opinion by the examiner based on what they see. If you look at it, you see the difference between what the examiner has cited and what you think your invention is. It may require you to amend your claims and or make the examiner understand the differences. You will get 3 months and to actually respond to the examiner's action, and you can actually pay for additional 3 months. We call that extension of time, to give you more time to review what the examiner has cited and how you want to respond. There's lots of situations. In some situation, examiner has done such a good job, you get that response like, oh, examiner found something that I hadn't invented, I didn't even know that existed, and you just let the case go abandoned. Or you look at it, oh, I see what the examiner is saying. He misunderstood my invention. I need to give him a little bit more feedback or response on how my invention works, or maybe even amend the claims. Because if you look at the claim, if you take a step back and look at the claim objectively, what was the thought process that's going to the examiner? Maybe your invention is a little bit broader than it should be. Maybe you need to add additional features in that claim to overcome what the examiner cited as his prior art. Or you need to, we call these arguments, you need to respond back to the examiner saying, hey, we disagree with your position on this, and then you respond. This is where your second bite starts, right? Examiner gets your response. Again, examiner, it goes on his docket. He looks at your response. A lot of things you can use. Oh, I agree with the applicant. Great, it's an allowance. Now, fun part for you is you're excited, you're happy, you can get a patent, but the other part is you have to pay some more fees. So you have to pay allowance fees. Or the examiner could, reject it, say, you know what, I disagree with your response, and I'm going to make my rejection final. An examiner can make his rejection final. Then you can, at that point, look at it, do a request for reconsideration. We call that after final response. Examiner will give you sort of a short response as an advisory form. He doesn't agree, or he may, right? And there are other things that can happen in between. You can request an interview with an examiner. You can sit down and explain your invention with him. Sometimes interviews help. And after all those things that you do, you may decide, you know what, I disagree with the examiner. I really feel strongly about my position. And then you can actually appeal. And you can appeal examiner's decision. It goes before Patent Trials and Appeal Board. And they decide to look at your arguments and examiner's arguments and decide, which side that they want to go. So there's a lot of paths there. There are other nuances in between this, and I can answer those if people have specific questions regarding this. But in a nutshell, that's how the process works. So a timeline, right? That's the hardest part. How long does it take, right? This is what we call pendency. It's how long it takes from filing of a non-provisional application to, we call it disposal, which is an allowance or abandonment, right? So roughly we're saying it's around 19.8 and around 20 months to first office action. Then the times get shorter because now the examiners have picked up the case, so you're going back and forth, right? The sooner you respond, the sooner the examiner responds back to you, right? We tell you that you have 3 months to respond from examiner's action, but you can also buy up to 3 more months of extension of time. So if you don't pay additionally for extension of time and you respond to examiner's office action within those first 3 months, it may go a little bit quicker, right? Again, a total pendency from the filing to disposal issue is roughly around 26 months right now. We are trying to improve that. Our goal is to continue to improve all these times. The biggest time that we can improve on is this blue area, and also the total time. The stuff in between all this from red, that's fairly static in the sense that we're doing the best we can to respond, right? We're as fast as we can. There's a lot of interaction back and forth during those times. The first chunk is the longest wait that you're going to have once you file a patent application. Sorry about that, my throat. Another thing is these 19.8 months, we do have some programs to expedite that as well. So there are ways to really expedite that time with special petitions and things like that. So I won't go into that right now, but that's also another thing that can be done. So what's a USPTO office action, right? It's really a correspondence between the examiner and the applicant, and it will set forth the basis for any objections or rejections or indications of liability. The summary, on the right, there will indicate the time period for response. So this is like the office action summary is a cover page. It has all the timings that we talked about. Usually 3 months is the time to respond. And what follows that, you'll have, another page on the office action cover page. And then there'll be a fairly lengthy rejection/objection. Depending on the technology area you're in, it could be as short as a handful of pages, and it could be long as tens of pages, right? 20, 30, 40 pages, depending on the complexity of the invention, technology, what examiner has to say, and depends in terms of whether there's only 112 rejections, the subject matter eligibility rejection, prior art rejections, as well as objections. So there are a lot of things that play into the length of an office action. So what does a rejection mean, right? I think I mentioned that earlier, right? Often rejection sounds very negative and discouraging, but the rejection after filing a patent application is a normal part of the process. Majority of the patent applications do get rejections. There are a small number that get an allowance right away, but rejections are issued because, one, we want to make sure that when we issue a patent, everything is clear. The public knows what the invention is. There's no errors. There's no unclarity. Claims are definite, and they're not overly broad, and they're meet our prior art standards, right? Rejections are issued to make sure patent applications are in complete compliance with the current state of the patent law and PTO guidance, right? Amending the case to comply with these requirements by an amendment, changes to the claim language, or address any rejections regarding any anticipation, obviousness, or indefiniteness. Those are either prior or non-prior art rejections, as well as negotiation between the examiner and the applicant, going back and forth. Where do we draw a line on those claims? Are they too broad or too narrow? And that's based on the prior art that the examiner finds, right? Examiner has a prior art that reads on the broadly recited claims, then you may need to amend it some and try to overcome that prior art. So it's a really fine tuning of your application to get to the right mix before it gets issued. So when you receive a rejection, obviously we don't want you to give up, right? If you look at this, there's a good percentage of office actions or rejections. Examiners are paid to do a search for cases that are relevant to yours, and oftentimes they find cases that the applicant did not originally find, because examiners are really specialized and experts in those areas. The examiners have to share how the broadest reasonable interpretation of the claim applies to these cited prior arts. So here's some stats on rejection and allowance. So in general, 89% of the original filed patent application filing will receive a first office action that contains a rejection. So eventually, 62% of these applications received an allowance as a disposal. However, these 62%, the allowance rate is actually understated because we actually count each round of prosecution of the same application as part of the allowance rate. So, for example, if applicant went through 2 rounds of prosecution, meaning they paid for a request for continued examination instead of letting it abandon, it would be 50% instead of 100% because each round of prosecution is considered rate in this calculation. So you should be optimistic about your patent application. So as long as you apply your invention in good faith and draft it by a seasoned practitioner. And really, actually, the number of applications that get allowed, after going through multiple rounds of prosecution is really higher, much higher. So this 62% seems really low. So if you've gone through multiple rounds, that number is very high. I think it's even the 80s, close to 90s. I don't have the exact number, but it's very high. So what exactly is the role of a patent examiner, and what do I do on a daily basis? All right. So as a patent examiner would have to understand the patent application first. And most of our patent examiners are engineers or scientists because they're technology experts, right? Your invention has a technology. And some of our examiners also have law degrees. They're attorneys and scientists. So the examiners, they review the contents of the application for compliance with all of our legal requirements. That includes search for prior art to see if there's early teachings of your invention before the filing date, of course. And then they have to evaluate your specifications and claims with search prior art to make the determination on allowability based on novelty and non-obviousness, and then decide if this patent application can be granted a patent. So for examiners, they have to respond to you in writing and provide findings and opinions. And of course, respond to any arguments you have when you disagree. We also hold interviews with applicants to discuss their inventions, and interviews can be over the phone, face-to-face, on-site, or virtually through a webcam. We do video conference interviews. Again, burden is on the examiner to show a patent application is not allowed, right? We always talk about the applicants have a right to a patent unless, and that unless is where examiner has to show under 35 U.S.C. 112, 101, 102, or 103 whether or not you should be denied a patent right. Right? You always have a right unless the examiner can prove otherwise. So we have those discussions all the time. All right. So the role of you as the applicant is to come up with all the exciting innovations. We want you to file for patent applications because we like innovation, right? And to file a complete application that satisfies all the check boxes. But it's important that you disclose all prior art that you might know, even if that prior art might provide an obvious determination on your application, right? That's your duty to disclose on what you know. For example, if you file an applicant, that claims an ultrasound system with a tablet, but if you know there's an article from IEEE that describes a computer with a tablet, you should let the office know. And if you know another article in a journal of nuclear medicine that describes a PET or CT system with a tablet, you should definitely let the office know. So let the office determine what is obvious and what is not obvious, what is relevant, what is not relevant. Patents are often taken to court, and one of the ways to negate paying licensing fees or lost income is by proving that patent is invalid. So some patent litigation does not end in patent getting invalidated, so it's best to disclose all the known relevant art. So the USPTO can do its best to allow a quality patent. If we know all the prior art that you know as well as research, you'll have a stronger patent. And then during prosecution, when you're responding to examiner's office action, all we ask is to make a good faith effort to explain your position and amend your claims. So if you get a final rejection instead of a notice of allowance, don't panic. Check that the final rejection for any indication that some of your application is allowable. Maybe your very last ditch claim is not rejected with R, and you can work with the examiner and still get an allowance. But a final rejection, you only have 3 options. You can pay for an RCE, which is a request for continued examination. That's where the new round of prosecution starts, where you get 2 more attempts, at patenting Apple. You can file an appeal, or you can take where you take the rejection to our PTAB, or file an after final response. after final responses, request for reconsideration that I mentioned earlier could persuade an examiner, to reissue an office action, or, maybe analyze the prior art, and they may decide that it's allowable at that time as well, right? There are a lot of things that can happen, but definitely don't want you to give up. There's a lot of avenues after final as well. So allowance is ideally your best outcome really is allowance. So these indicate that your application has met all the requirements and overcome all rejection and is ready for an issuance. So, and this is where you celebrate, right? You can get a patent. So we talked about 62% of examiners disposable allowances, but remember, if you filed our RCE, this percentage is probably higher. So, again, anatomy of a patent, right? So once you get a patent, here's an example of what you'll see. A few things change from published patent applications are new records of reference cited, there are prior art record, and your patent number and date of patent issued, and the name of the examiner who allowed your patent application, and your legal representative's name as well, right here. So they're all different parts. I think there's a lot of resources available to you. I know I've talked a lot, but I want somebody else to talk. So I'm going to really turn this back to Mary Fuller, and she could talk about support and resources.
Fantastic. Tarek, that was such a treat to hear from you. I am going to share some resources with y'all. I'll go through them pretty quickly because there are a couple of questions in the chat that we would like to ask Tarek to answer. So I don't want to take up too much time. I do want you to know there are resources available. Could you go to the next slide, please? First of all, I want you to know that all of our resources, all of our educational and training resources are free. And that's an important thing to know. You can find our resources, as it says here, at www.uspto.gov/free services. All right, can you go to the next slide, please? One of our important resources is the USPTO Patent Pro Bono Program. This is a nationwide program, and we provide pro bono, and that means free services to people in all states, all 50 states. And you can see how on this map they're different colors, right? And that's because each color represents a different pro bono organization. So we've coordinated with these pro bono organizations to make sure that you are able, if you are matched, so you're able, if you are matched or qualify, to get free services in every state in the United States. I sit in California. So here's an interesting thing. So you see how California is dark blue? And well, please note that other states are also dark blue. So Washington, California, no, it's not Washington, Oregon, California, Nevada, Alaska, and Hawaii are all served by a pro bono organization called California Lawyers for the Arts. Now, if you were sitting in Alaska, you might not realize that because it sounds like California. But if you go online and look at our pro bono patents, so www.uspto.gov/pro bono patents, you will find out who serves you. You can go to their website. Each organization has a slightly different, or typically has a slightly different qualification program. Most of them will serve people who make up to 3 times the U.S. poverty rate. So you can find that information. But you know, sometimes you make a little bit more money than that, and you still want to have services that are reasonably priced. Again, if you contact your local pro bono organization, they often can put you in touch with what we call low bono or less expensive legal services for patent work. Can we go to the next slide, please? We also have a program called the Law School Clinic Program. And if you think, well, I don't qualify for a pro bono program, and I could reach out to the low bono, but I really would like to have free services, this is another option. Here, if you go to our website, so /law school clinics, you'll see this map showing you where all the clinics are. They're in universities all over the United States. And there's also a list. And when you look at the list that's online, that list tells you specifically what each of these law school clinics does. Some of them only serve people who want patents. Some only serve people who want trademarks. And some serve both. The great thing about looking at our law school list is that you can ask a law school anywhere in the United States to help you, because patent law is federal law, so you don't have to limit yourself to a particular state. Can we look at the next slide, please? We also have patent and trademark resource centers. Patent and trademark resource centers are found in over 100 libraries around the United States. Last count, I think it was 102. If you are somebody who's thinking, well, I think I have intellectual property, I'm not quite sure what to do next, I think I want to file a patent, or I think I want to think about whether I'm eligible for a trademark, you can go to a patent and trademark resource center library. You can find them on our website at /PTRC. I think that Marilyn is sharing all this information in the chat links for you that you can pick up there. You can go physically to one of these locations, or you can make an appointment to talk to a PTRC librarian. These are librarians who have been trained by the USPTO to help you get started on your innovation journey. Now, they are very often not attorneys. They are trained in helping you get started. They cannot give you legal advice, just like we can't. And they also cannot, for example, search to see whether your particular invention has been done before, but they can teach you how to do it. They can give you clues, and they can help you along your way to make the path to being a registered IP owner easier, and to make you more confident about the direction you're going. Next slide, please. We do have a helpline, and I really recommend to folks, especially if you are filing a patent application on your own. I think Tarek mentioned when he was showing you the faceplate of a patent that sometimes you'll see an individual's name on their own. That means a person did it themselves, right? And that's called pro se. So if you are a pro se applicant in particular, or if you are a small company, or even a small law firm, you can call this helpline. These helplines are staffed typically by often just recently retired, very senior patent experts. So often folks who have been at the patent office for a long time. They've often been supervising patent attorneys, or maybe even TC directors. And they can help you find the answer to your thorny questions. I want to let you know that the hours have shrunk a little bit. So it's 9 to 5:30 Eastern now. If you're on the West Coast like I am, you have to plan for that. And our like everything, our staffing has also shrunk a little bit. We are there. You might have to wait on hold for maybe even up to 30 minutes. Don't give up. Experienced people are there to help you. Can we see the next slide, please? All right. If you are a self-starter, or I want to do it my way kind of person, and I want to do it now, we have educational online resources. Again, all of our educational resources and training, all that is free. So if you're a self-starter who wants to learn how to do it yourself, or who wants to learn more about patent lingo especially, so that you can interact more effectively with a patent attorney, we recommend that you go ahead and check out our online educational resources. Next slide, please. Again, we have filing guides. So for non-provisional, remember we have those regular patents and non-provisional utility patents. If you think, oh, I want to file a utility patent, I think I have a great idea, I have a lot of questions, we have filing guides and checklists online to help you on your way. Next slide, please. That's it. Thank you so much for being with us.